Well, good morning or good afternoon, wherever you might be. Greetings from Malibu, California. I'm Pete Peterson, the very grateful Dean of Pepperdine's Graduate Policy School, and I'm coming to you here live from the Dean's Conference Room on our Malibu campus, moderating an important and timely conversation: municipal climate litigation in California. Should the courts or policymakers address climate-related damages and solutions? This is just the next in an ongoing webinar and event series that we have been hosting for the last several years, called DC and Capitol Hill to California Conversations. Over the course of the last several years, we have been exploring, both in events and in webinars like this one, policy issues that have a particular resonance both at the federal level as well as the state level here in California. Over the course of the last couple of years, we've explored housing policy and mortgages. We have looked at various issues pertaining to municipal finance. And today we will be looking at climate litigation, an issue that obviously has implications for all levels of government. The format for today's conversation will be the same as we have traditionally. We're going to begin with a conversation discussion with our three panelists, and then over the course of about 35 or 40 minutes, we will then weave in your questions. All of you should feel free to enter in your questions at any point in this webinar by using the chat feature at the bottom of the screen. Simply type in your question and I'll make sure we get to those in turn. Let's introduce our panelists for today's conversation. First, Kevin Faulconer. I'm delighted to say he's our visiting professor for community leadership and government innovation here at the School of Public Policy, and comes to this position after 2 distinguished terms as mayor of the great city of San Diego. Under his leadership, the city was known for responding to issues related to climate and the environment, and we'll certainly get into some of those today. Professor Holly Doremus is the James H. House and Hiram H. Hurd Professor of Environmental Regulation at the University of California, Berkeley, where she is also the director of the Berkeley Law Environmental Program and co-faculty director of the Center for Law, Energy, and the Environment. After law school, she clerked for Judge O'Scanlan of the United States Court of Appeals for the Ninth Circuit and practiced law in Corvallis, Oregon. Delighted to have Professor Doremus with us. And finally, Phil Goldberg. Phil is a special counsel to the Manufacturers Accountability Project, and a project which is a project of the National Association of Manufacturers. He's also a managing partner at Shook, Hardy and Bacon. As a public policy attorney, Goldberg has more than 2 decades of experience with liability-related public policies. From '93 to 2000, he worked for Democratic members of Congress, including Steve Rothman from my native state of New Jersey. When Mr. Rothman served on the House Judiciary Committee, he has spoken and testified before legislatures and filed amicus briefs on issues relating to public policy and the environment as well. Important for you to know that today's conversation is intended as also to be kept within our tradition at the Policy School, to highlight conversations in which there's a certain degree of what we would call viewpoint diversity here at the Policy School. It's important as we're exploring issues of such import, like environmental policy, that we hear from different sides of the issue. And that's why, again, I'm so delighted to have not only people presenting here, we're engaging in conversation that come at the issue from different positions, but also have explored it in different ways, both as policymakers as well as those working through the courts as well. That's going to be another dimension of today's conversation, is how we should understand the best path toward policymaking in such a crucial area. So why don't we begin just to introduce each of you to our audience here. Mayor, we'll begin with you. Obviously, the city of San Diego under your leadership was known as being one that addressed and tackled issues of environmental policy related to climate change. Talk a little bit just about some of the work that you did there as a city mayor of one of the 10 largest cities in the country and a coastal city to address some of these issues.
Well, thank you, Dean. Greetings to everybody. I will tell you, as we've talked a little bit before, I do think, even though you mentioned the viewpoint diversity, I think there are a lot of things when it comes to our environment that you have unanimity of consensus that it's important to have clean water. It's important to have clean air. And I don't care whether you're a Republican or Democrat, you want to be able to enjoy all of that. And so I think the question becomes, how do we achieve those goals? And one of the things that we took a pretty aggressive posture in San Diego was when we were developing our climate action plan, which is, to me, it was important not just to have goals, but really what are some of those measurable effects for our climate action plan that would really make a difference. And to me, Pete, it was, how do we actually put in place a policy that will provide incentives to achieve the results that I think we're looking for? And I use that word incentives because I think that really becomes some of the best way that you can achieve results the quickest. We did come out with our climate action plan, and some of the highlights of that in terms of the ability to move to community choice energy. We're one of the first big cities in California to actually do that completely. Give consumers a choice in terms of how they want to procure their electricity and the amount they want to do from renewables. That has been extremely popular in San Diego and more popular, as I think, as it goes by. We also invested a lot. We tend to get we go back and forth with our friends in Los Angeles and Pepperdine and up in that area on where we get our water. We're at the end of the tap here in San Diego, and so take pretty aggressive stances on moving forward with one of the largest water recycling projects on the West Coast. That, when completed, we will get a third of our water supply in San Diego from recycled water. We call it our Pure Water program. Not inexpensive, but again, it's extremely important from a reliability standpoint, from a resiliency standpoint, to provide that infrastructure to do that. And that was something that was, pretty at one point was not very popular, right? Recycled water, and now is extremely popular across the board. And the last thing I would mention, again, from a climate standpoint, and wanted to provide incentives. We know that if we really want to reduce vehicle trips, emissions, others, we have to construct housing closer to our transportation corridors. And so we made a huge effort on a plan that we called Complete Communities, which was to provide incentives. So folks, if you were going to build housing, encourage and increase the density, we made it easier for you to do that. We did a citywide environmental impact report so we can cut down the timing so you can get that type of permit over the counter. Again, time is money. And if we want to incentivize constructing housing close to our employment centers, close to transit, I believe you have to provide the incentives for people to do that. And we're seeing, again, a huge acceptance of that. And so, I'm looking forward to today's discussion because I think sometimes there is a role for, quote, lawsuits, but I think you can affect a lot more positive change if you get people together around the table and hash out policy that I think has the greatest amount of effect, and it has a quicker effect. Lastly, I would just say, when we did our climate action plan, now I vividly remember some of the meetings that we had in my conference room. We had environmental groups, we had the Chamber of Commerce, it was all about, guys, what can we do that we can achieve? We may not agree on everything, to your point, Pete, but I wanted a plan that we could all get behind. And again, that would have some measurable objectives and actually move the needle, not a plan that was just going to sit on the shelf and not do anything. So that's kind of the perspective that we took. And I think one that at the end of the day, when we're looking to actually make some positive changes, it's the best way forward.
Well, again, one of the lenses through which I think this conversation can best be understood is thinking about how public policy is made. And your work there in San Diego certainly shows what municipalities have been doing and can do. At the same time, we are seeing a growing number of cities attempt to address some of these issues through the courts. And so as we move to the two lawyers on this panel, Professor Doremus, why don't we start with you? We are seeing a growing number of municipalities bring climate-related lawsuits against energy companies, by and large, related to the perceived impacts of the work that these various companies are doing on their particular communities. Before we get into some of the specifics, if you could talk a little bit about your feelings as a policy-making mechanism, why you may think that the courts are an adequate route for addressing these much larger issues.
Well, I would start, Dean, by saying I've never said the courts are an adequate route. That's not to say that they don't need to be part of it, or that it's not appropriate for them to be part of it. I think I would frame the title of this presentation a little bit differently than you all have. It's, it's presented as courts or policymakers. And courts are one of the institutions through which we make and implement policy. But they're certainly not the only one. Climate change is an enormous challenge. It's a challenge both in terms of controlling, limiting emissions and responding to emissions that have already occurred and are occurring, right? So we may need all of our societal institutions, including private actors and private industry, to deal with this. And I'm all for having incentives. I'm all for the local governments, for example, have the capacity and often the legal responsibility to deal with things like where is housing and where are roads and how are those kinds of choices made. And those have a huge impact on climate outcomes. But there may be some things that legislatures and regulators are not doing that courts are perhaps better positioned to do, although it clearly is a challenge. And one of the things to think about, the current wave of climate lawsuits by cities and counties and states is largely focused on holding oil companies, fossil fuel producers, oil companies and coal companies responsible for harms that they're creating. And there may not be other institutional mechanisms for getting compensation for damages that have occurred or funding for adaptation needs from these specific actors. And it may be appropriate for those actors to pay certainly a share of this if they're responsible for creating the harm. And one thing that economists would tell us that liability can and should do is to force industries to internalize the costs that they create so that the product producers and the product consumers pay the full cost that they're imposing on society.
Very good points. Phil, let's come to you. your thoughts on the place that courts can have. I think Professor Doremus is right. We in the sense that we know that courts have been policymaking institutions, currently are policymaking institutions, one avenue from which policy is derived. But in this particular area of environmental policy, and to Professor Doremus's point about courts playing a role in creating incentives for companies to behave in certain ways. What are your thoughts on the use of courts as part of the mix?
Well, first of all, Dean, thank you so much for having us, for putting this conversation together, for including me. I really appreciate that. And Professor Doremus, her qualifications clearly are phenomenal, and I look forward to learning from her as well today. And Mayor Falconer, thank you for joining us. And gather you're the old hand here, and I guess you should. We're the ones who are the newbies. But I'm always frustrated when I get to be part of these kind of events that are in awesome places like Malibu, and I'm sitting here in an office across the country. This damn COVID stuff. But it is what it is, and it's great that we can do these kinds of programs.
Yeah.
I think the broad concern here that the manufacturing community has is what we're dealing with are really political, social, and global environmental issues. And there's this effort to try to make manufacturers or people that are involved in the commercial activities around those responsible for them and have to pay the cost for them, which really then, as Professor Doremus indicated, kind of drives up costs for consumers. And that may not be the right answer for a lot of people. I think I'll start where I think we all agree, and Mayor Falconer said this. We all agree there's a problem. We all agree that climate change is a problem. It needs to be solved, and it is in part, it's caused by a lot of things, and in part by the use of fossil fuels. And so that has to be part of the solution, is finding ways to innovate and finding innovative ways to source and use energy in a way that's sustainable for the climate. I think if we look back and say, kind of, why are we here? You look at, and most people will say, electrification and the use of energy over the last 150 years has been one of the greatest advancements of modern society, from, the ability to, increase human health and standard of living, refrigerate food, heat and cool homes, transportation, healthcare. This has all been a phenomenal success story of quality of life and standard of living and health over the past 150 years. Now, how we got here to this point is clearly not how we're going to continue doing that, because our use of the way we are doing that in modern society is not sustainable. So we have to figure out how to innovate the ways to change that. Where I think we disagree, at least that where the professor and I disagree, is on solutions. Like, so what are we going to do about it, and how does this litigation fit into real solutions? And so the first thing to just throw out there, this litigation is not going to solve climate change. And I think Professor would agree with that. Even the complaints say, we're not trying to stop anybody from selling fossil fuels, which is somewhat, frankly, indicative of the fact that there really isn't a lawsuit here, because they're saying, oh, go ahead and keep selling your fuels, just make sure you give us money so that we can deal with that. And by the way, you're selling it to us and we need to keep using it, and so do our citizens. And so the idea that this isn't about actually doing anything about climate change or about production and all that about fuels kind of exposes that there's really no foundational element here in the legal system for these lawsuits. And that's frankly what the Supreme Court said when they looked at this, a similar type of litigation 10 years ago. They said these are really policy decisions, and not policy decisions that courts tend to make. These are policy decisions that really belong in the legislative and regulatory bodies, because you have to look at what, if we drive up energy costs because of this litigation, how does that affect people's ability to pay for energy? How much does it cost to put fuel in your car, to heat your homes, to your electrical bills, and can people afford that? And what does that mean for energy security, which one of the things the Supreme Court talked about? And obviously that's become a huge issue over the past year with the Russian invasion of Ukraine.
Mm.
there also are downsides, both from a social, in terms of cost, but also downsides for the climate. And we can explore that as the hour goes on. But there's already been talk about how as American and European energy companies start retracting their production of fossil fuels, the OPEC and others are increasing theirs. And these lawsuits, by the way, they only target, American and European and Canadian companies, are not going after the OPEC side of the world. So, there's an imbalance to that as well. And so at the end of the day, this litigation isn't very useful. It distracts from what needs to actually be done. And what we need are real global solutions on how we're going to deal with all of this. And to the extent that this is really just about trying to get money to communities, which I'm very sensitive to, there are, especially in California, state programs that are available. And then in the Inflation Reduction Act, the Biden administration just made billions of dollars available for climate adaptation costs, specifically for this kind of stuff. And so I just, where we come from is this litigation doesn't help. It can only hurt, and it can have impacts that are really bad for people and businesses.
Before we get into some of the specifics about the state of the law on this issue and where some of these cases are, and bring in the fact that the Supreme Court is, at least the specter of the Supreme Court is there on this set of issues. Mayor, I wanted to come back to you because I see that we have other mayors on the call here, and I know others registered who will be watching this later. Walk us through, for maybe people who aren't mayors, how cities make decisions on whether to engage in particular lawsuits or not. Now, certainly in some cases, you're a respondent as a municipality. A lawsuit is brought against a city, but and the city attorney's office, depending on the size of the city, you may have your own city attorneys, others can be contracted. Talk to me a bit about how decisions are reached as to whether a city would move forward on a litigation such as something like this.
Yeah, and I think you're right, Pete. There's no one particular avenue. Certainly, as a city, you get sued all the time as a respondent. We're used to that. But in the case of San Diego, as an example, we have an independently elected city attorney, but who will bring opportunities, if you will, or potentials to join lawsuits through the city council, and we would deal with those in closed session and then report out actions, obviously. In the case of San Diego, as mayor, I sat on those closed sections. And I think it's really what is the opportunity? And that's kind of that debate back and forth. I mentioned earlier, and you get approached a lot from national folks on a variety of topics, not just climate topics, but have class actions that want a city to join or not. And so obviously I think some of that gets filtered through the city attorney's office, and then ultimately some of those make it through, and it's up to the council to decide that with the mayor. But I think sometimes you have a more direct opportunity, if you will, on if your city's getting harmed directly. We talked a little bit about last week, I think when we were chatting, in the case of San Diego, one example that I used is we joined a federal lawsuit, because we have, from an environmental standpoint, one of our worst issues that we're dealing with is the untreated raw sewage coming over the international boundary and border. It's been a huge problem in San Diego County for 30 years. And we made it a real priority to say, we have to fix this. And so joined a lawsuit, yes, but then also worked very, very hard when USMCA was reauthorized to have Congress finally appropriate some dollars to help fix that in terms of infrastructure on both sides of the border. So I think on the one hand and we're still dealing with some of that, obviously, but that, in my opinion, was a example of how a lawsuit was the right approach, because we were getting harmed. Right. Also, I think helped provide some leverage on the policy side, in this case, when Congress was doing that, to help with that appropriation. So That's what I was talking about. And I think the professor got into this a little bit. It's not necessarily an either or, but I think in this case, very demonstrable impacts in terms of clean water that wasn't happening in terms of our beaches, particularly in, Imperial Beach, right to the south of us in San Diego. So, I think to bring that full circle to answer your question, that's where I think your elected officials have to say, okay, how is this really impacting us? What are our chances of, how is this really going to do that? Because I always took the position of, I want us to be involved in lawsuits that I think make sense. And I don't want us just chasing a bunch of things and getting distracted on things that, again, aren't going to really have an impact, and really trying to focus more on the policy standpoints. What can we do to make that change, locally, and or use our voices on a statewide or national level, and to beat that bully pulpit, because I think it helps.
Yeah. Well, that's a good segue back to you, Professor Doremus, in thinking about the courts as an avenue to remedy climate-related harms or damages. It's one thing to see raw sewage spilling into one's community. That's a pretty easy thing to identify and understand. That is something that needs to be responded to. One could foresee that there would be challenges in understanding the impact of climate change in particular communities that are separate than that, whether it's warming trends or even sea level rise. What are your thoughts on the ability of courts, and specifically judges, to understand or interpret the specific link between, say, a particular manufacturing or energy company operating and a localized issue, say, for example, like sea level rise, that many understand as having been triggered by much larger forces, whether globally or even nationally?
Let me see if I understand that question appropriately. To win a tort suit, you have to show that the defendant caused the harm that you're complaining about, right? So that is going to have to be part of it if these lawsuits go ahead. I think a number of them focus on the clearest current impacts of climate change driven by greenhouse gas emissions. And actually, there's very good agreement that increased greenhouse gases in the atmosphere have increased global average temperatures and are continuing to do so, and have increased sea level and have accelerated sea level rise and are continuing to do so. So we've got hotter days. We have in California more vulnerability to wildfire, both because there's more dead fuel, there are more trees that are dying as a result of heat and drought. Sea level rise is occurring, and sea level rise is already tied in a number of locations to increased flooding. There also is a sort of generalized increase in storm extremity, which is, depending where you are, I think can be shown. And I'm not a climate scientist, so I'm not a person to go on too much about this, but there's now this idea of attribution science. And there are some real efforts to say how much warming correlates to how much sea level rise, how much temperature increase, how much of these various impacts, and how much greenhouse gas emissions correlates to that much harm. So it's at least theoretically possible to say, well, you produced fossil fuels whose burning produced this much in the way of greenhouse gas emissions, and that's tied to this level of harm. So you can try, if you're looking at liability, you can try to assign responsibility to these actors based on what they've done. So it's true, as Phil points out, these lawsuits don't include OPEC oil producers, they don't include Venezuela, they don't include Mexico, which has a national fossil fuel production, because those entities can't be successfully sued in these courts where these are being pursued. But that doesn't mean that it's not at least theoretically possible to say, well, Chevron, you're responsible for so much of Oakland's climate problems, right? And that's the way I think this would have to proceed. But I want to be clear, I do not think that courts are the best place to approach climate adaptation or climate mitigation.
Yeah.
And I don't know anybody who disagrees with that.
Yeah.
But so far, we don't have effective legislative responses at either a global or a national level. We have a climate accord. Countries are not living up to it. There's not a lot that can be done to enforce that. We don't have a US federal greenhouse gas emissions law. And we came close at the beginning of the Obama administration, but fossil fuel producers and others opposed it, even though it was based on a market incentive kind of approach, and it didn't quite get through. I think in some respects, you have to look for what answers you can get. And I guess I also agree this clearly is a global problem, but it cannot be the rule that only measures that could globally solve the problem can survive or are allowed, because there is no one measure that will solve this. And actually that's one positive thing the Supreme Court did several years ago in 2007 when it decided Massachusetts versus EPA. It said that lawsuits can proceed and causation can be shown when there's a significant contribution to the problem. You don't have to show that you would solve it through this litigation.
Yeah. Well, Phil, I want to come to you just on that and to dive a little bit deeper into the specifics of the legal approaches that have been taken. To Professor Doremus's point, it has been in the area of tort law where these suits are being brought, but specifically looking at issues of either public nuisance or consumer protection. Your thoughts on the current state of play on these lawsuits, and are you seeing one type of tort lawsuit making more headway or less than another? Oh, you're muted, sir.
Sorry, I was trying to be good and be muted.
$5 into the pot.
That's right. You think after this far along in the pandemic, we would have gone. No, that's a very good question, and I'll walk through a little bit of the liability theories, but I do want to respond to one thing that Professor Doremus said, and she talked about causation and attribution science. And all that is saying is that these companies should be responsible for selling us oil and gas that we use every day to the amount that they sold it to us for. That's not a liability theory that is viable in the courts. Courts are not based on what's called cause and fact. And then again, you can't even show cause and fact here, even with the attribution science, but say you could. It's based on wrongful causation, what's called proximate causation. And so you have to have done something specifically wrong that caused the harm that the person's alleging that you caused. You know, and so if it wasn't wrong, then that's not a tort. That's not what tort liability is for. And that's kind of what the regulatory legislative body would say, here's what's right and wrong. Then if you do wrong, then we can sue you for harming us. But the courts, especially in this area, we're dealing with climate change, really don't have the ability to set those standards where they can say emitting this much was wrong, doing that was wrong, and what have you. So, you know, the idea of this attribution science and all of that is really off the point when it comes to liability, because it isn't looking at the right question. The two theories, as you said, that the lawyers that are bringing these lawsuits are mostly relying on are public nuisance and consumer protection. And both of them are being used for a specific reason. They have very broad language to which that they can apply to, but they're meant to apply to a very defined area of things. So public nuisance, for example, is about local disturbances, vagrancy, things that are happening in a local community that are interfering with public rights. So someone blocks a road. So if there's, you know, point source pollution in a public river, and you're not letting people use that, and it's all very localized, that's what the tort of public nuisance for. Now, it could apply to a whole variety of local disturbances, which is why you have some broad words, but it's all about that. It's not about global climate change and, you know, production and sale and use of not only just fuels, but all the other things that, you know, that are causes of climate change.
Right.
The Consumer Protection Act similarly are about if you're selling someone something, does the product work the way it's supposed to work? So if you buy a gallon of gas, did you get a gallon of gas? Does it work the way a gallon of gas is supposed to work? It doesn't look at, you know, anything that somebody's say, if I had known this, I wouldn't have bought that product. So it's externalities, right? That's what they're talking about. If I had known that fossil fuels would be a contributor to climate change, I would never have bought fossil fuels. Well, first of all, everybody has known that. It's been out there since, you know, the Kennedy administration, and certainly the Johnson administration, and people have been studying and talking about it for 50 years. It's known. That's not what's at issue. And if you look at and other products, I mean, there's a whole variety of products that have externalities, energy and others that you don't have. Just because you don't talk about every potential externality doesn't mean that you engage in a Consumer Protection Act violation. The second thing is they're going after is political speech. And so, you know, there may be some, you know, companies that if I knew that their CEOs or their owners were spending their money on this, you know, political thing, I might be like, I don't want to give them my money. But if they don't tell me that and I go buy their product, you know, or their chicken sandwich, then that's, you know, I can't sue them for not telling me that, right? Like, that's not what Consumer Protection Act is for. When I got the chicken sandwich, was it a chicken sandwich? Did it taste like a chicken sandwich? Did I eat it? That's all that matters, right? And so that's where, you know, these two theories of liability, this idea of this public nuisance, which is all about these local disturbances, and this Consumer Protection Act, which is all about making sure that the product is what you actually sell somebody, then they have nothing to do with, you know, the global debate and discussion over climate change, what we're going to do about it, and how we try to innovate our way out of this. And so that's why they're in there, because they're so squishy that they could try to make any argument that they could try to make out of it. But at the end of the day, that's not what's going to, you know, when the courts actually apply the law, these cases should get dismissed because they're not stating viable legal claims.
Well, I want to come back to that in a second. Just a moderator's note here. I'm seeing some questions coming into the chat feature. And again, encourage all of you to enter questions. We'll be getting to those here in the next few minutes, as I see some really good questions here already. Mayor, the discussion around, to the degree I know San Diego, beautiful city, I know there are different parts of San Diego, you know, some are more industrial than others. In your thinking through as a mayor and as one who is looking to, you know, generate business and welcome economic development, how did you think about the different obviously you have different zoning laws that allow for different types of companies and manufacturers to operate in different kinds of places.
Yeah.
How was your thinking on the environmental impact of particular companies, even if it was very, if it couldn't directly be connected, say, to global warming, it may have had some sort of other impact with, release of chemicals or something like that. How did you think about the importance of zoning as and where residencies sit next to particular commercial districts as being an important tool in the toolbox of municipalities in addressing either things like localized climate impacts?
Great question. And you think a lot about it. And particularly, we were updating our community plans. And it's an ongoing process, but in the second largest city in California, eighth in the country, we spend a lot of time on where do you want that growth and development? And probably just as more importantly, where don't you want it?
Mm.
And in San Diego's case, our community plans are those documents that say, here's where we want it. And so here's where you can actually do it. And so as I think back, Pete, I'll give you a good example. Some of the back and forth we had on our Barrio Logan community plan update, which is down by the ship repair yards in San Diego, which is extremely important from an economic standpoint, also national security is
Yep.
The largest Navy footprints in the United States here in San Diego. So that ability for the ship repair industry to operate, to be successful, to have those jobs, and yet at the same time recognizing, okay, where do we want that buffer zone, if you will, or what types of not manufacturing, but some of the repair facilities that we have in San Diego. Where's an appropriate place to locate that, and where do you not want housing right next to that? So that, to answer your question, that is I believe extremely important, and that's why you have to put that thought into it, and then back that up, because, and to me, it has never been an either or. And if you start talking about either or and absolutes, I think then that's where you're not going to get anything done. Again, how do you strike that balance that says this is important for our community, this is also important for good quality jobs in our city and the things that we're doing, and how do you be smart about it? How do you say to a type of company, here's how you want to have your truck traffic, and not actually run it through a residential neighborhood. You need to go through there. Here's how you have to incentivize your fleet so you can have in terms of different emissions and make those part of the condition. So I think you spend a lot of time on that, and I think rightfully so, because again, you want to ensure that you are not just protecting your community, which is incredibly important, but again, you're doing it in a way that says it's not an either or from a jobs and business standpoint as well.
Professor Doremus, I wanted to see if you could give us an overview of, I alluded to before, the specter of the Supreme Court and where they may be playing on this issue. There hasn't been a lot of action at SCOTUS around these issues, and to the degree that there has been, they've been fairly cautious about being engaged in lawsuits related to climate mitigation. Your thoughts on where the Supreme Court is now? Obviously, this is a growing national concern, so one could see that there's a certain timeliness here to the court and cases making their way up to the Supreme Court. Where do you see the court now, and are there cases we should be looking at as bellwethers?
Yes. So far, the Supreme Court has addressed 3 cases that deal with climate change, although not all in somewhat different contexts. The first case was Massachusetts versus EPA, which came out in 2007. And what that said was the Environmental Protection Agency has a legal obligation to evaluate the impacts of greenhouse gas emissions from automobiles.
Hmm.
and to decide whether it has a legal obligation to regulate those, which it subsequently did and decided that, yes, it did have such a legal obligation under the Federal Clean Air Act. Then in 2011, and I think Phil mentioned this case, not by name, there was a case about Connecticut versus American Electric Power versus Connecticut, as it was called at the Supreme Court. And that was a challenge by a number of states. They sought to sue utilities, the largest utilities in the country, some of the largest fossil fuel powered utilities, and therefore some of the largest emitters of greenhouse gases, on a theory of federal public nuisance. And the court said that, no, you can't use federal public nuisance for that because the Clean Air Act has entirely displaced that. That I think is right, because the court has long held that if Congress makes a statute dealing with an issue, then it probably doesn't want the courts, the federal courts, to be resolving that that issue. The latest climate change case at the Supreme Court was Baltimore versus BP, which is, it's a highly technical procedural issue about appeals of decisions to send cases back to state court. And we don't need to get into that here, but it is important to this wave of municipal and state litigation that we've been talking about. It deals with this kind of tort litigation. The plaintiffs in this litigation believe that state courts are likely to be more receptive to their claims. The defendants in this litigation believe that federal courts will be more sympathetic to their views that this litigation shouldn't happen. So in all of these cases, the defendants have sought to get them into federal court. The plaintiffs have sought to keep them into state court, saying we're only raising state issues. In Baltimore versus BP, what the court decided was that federal courts of appeals have to look at all the dozens of grounds, actually it's not quite dozens, but about 10 grounds that are being claimed for why these should be in state court rather than federal court before they approve sending them back to state court. Since that decision, every one of the cases that sent a bunch of these cases back to the federal courts of appeals and the federal trial courts. So far, every court of appeals to decide one of these cases after Baltimore has said, yes, these belong in state court, considering all of the reasons for sending them to federal court. But one of those cases, Boulder versus Suncor, the defendants filed a petition for certiorari. That's a motion asking the Supreme Court to hear the case. And the Supreme Court has asked the United States for their views on that, which is an indication that the Supreme Court's quite interested in it. And who knows, I certainly am not good at predicting what the Supreme Court would do.
Who among us is, though?
Based on my understanding of what the justices are interested in these days, I think it is not unlikely that they will take that case up. And that would not decide the merits of these cases. It would decide whether they belong in
The levels.
Federal or state court. And as I said, both the defendants and the plaintiffs think that matters a lot.
Phil, you're obviously in DC, you're following these machinations as well. How do you see the role of the Supreme Court, and in particular this case that Professor Doremus highlights that could set precedent on where these cases should be considered?
Yeah, I thought Professor Doremus did a great job kind of walking through the history, and the history here is important because, I think we heard this a little bit earlier when Professor Doremus was talking about the frustration that things aren't getting done in Washington, or at least the things that, the people behind these lawsuits want to see aren't getting done in Washington. I think we all are frustrated about how politics have seemed to break down or broken down over the past few years, especially those of us who are here and try to actually get things done for people.
Mm.
And so on a variety of issues. And so, that frustration was very palpable back when the cases were first being brought back in 2004, 5, and 6. And that's what they talked about. They talked about how, are the courts the right way to regulate climate change and greenhouse gas emissions? And you had comments from the people bringing the cases that that's exactly why they were doing that, just like Professor Dream was saying here. The problem it was find a little bit disingenuous is that some of the people who are bringing the cases now are saying, oh no, that's not what this is about at all anymore. This is just about trying to get money to local communities, or about this or that. We're not trying to affect policy. But that's really when the Supreme Court spoke back in 2011 is what they were concerned about. They said these are inherently political issues. They said, and it was Ruth Bader Ginsburg is the one who wrote the opinion. It was unanimous by the court. They called it an issue of special federal interest, and that borrowing the law of a particular state would be inappropriate. And Justice Kennedy said in oral argument, it would be odd to have, if we're saying a federal court can't come in here and do the job of the EPA, it would be odd to have state courts be able to go do that. And so from 2012 to 17, before these new cases were brought, there was a concerted effort by the people who are behind these lawsuits. And this is one of those things where you don't have to take my word for it. They actually published a report after a meeting they had in California back in 2012, saying exactly, how do we now repackage this AEP versus Connecticut lawsuit in a way that looks different to courts, that try to get into state court, try to, instead of suing the energy, the utilities, let's sue the energy producers. Instead of, federal public nuisance law, let's do state public nuisance law. Instead of asking for injunction, let's ask for a different remedy. And so, but all the while, the goal was the same, was to figure out how to, as Professor Dream has said before, how to get the energy industry to price into the cost of energy.
Right.
It's the impact that it's having on climate change, and obviously drives up the cost for the rest of us. And the lawyers in the Boulder case have said that this time around. They've said, this is about raising the price of energy. It's about holding consumers responsible, and ultimately those are issues that need to be decided in Congress and in the regulatory bodies. And so when you look at the cases that are before the court now, or at least the main case, which is the Boulder case, that's the question. Are these, if you look at AEP versus Connecticut, you look at all of the Second Circuit issued a similar ruling, when it threw out New York's climate case a couple of years ago. That these are federal, they belong in federal court, they're federal issues, or can, through sort of creative pleading and packaging, can the people behind these lawsuits file cases in state court and try to get a state judge to say, I'm not going to pay attention to what the Supreme Court said. I'm not going to follow that. I'm going to try to get money for, local, for the local communities. Yeah. And that, and that's why this issue is so important. Because when we deal with, how are we going to deal with climate change? How are we going to do it at a global level? How are we going to do it at a local level? How are we going to pay for climate mitigation? Whose responsibility is that? How are we going to, innovate ways to source and use energy the way that's sustainable for the climate? How are we going to do all of that? Those are not decisions that should be decided in the state court, and state court by state court with different answers in every state court around the country. These are national issues, and at some level international issues, that need to be resolved at that level. And that's what this case before the Supreme Court right now, as to which ballpark do we even go into, is so important.
I wanted to, in our last 5 or 6 minutes here, we've got some good questions. One in particular is fairly germane in that it is proximate to here. We have a discussion about the Aliso Canyon gas blowout and leak. I don't know if, I'm guessing Professor Doremus might remember this, but down here in this part of Los Angeles County, we had a major gas leak. And this question is brought by one of the area city council members who's been responding to that. And his question relates to the lawsuits that did bring greater oversight and some mitigation funding for the leak, but regulatorially, I don't even know if that's a word, but I'm going to bring it in. Regulatorially, his point is that the Public Utilities Commission and Sacramento, by which he means the legislature, are still the ones that are controlling whether the wells are open or shut. And I wonder if that could be used as a broader question around how lawsuits or the role of the courts is used alongside what is an increasingly regulated industrial base, if you will. That in California, we do have a number of regulatory bodies, especially in the energy sector. We have something like the Public Utilities Commission. And understanding where the target of those lawsuits should be. I think what this particular council member is raising, that if there were to be further lawsuits regarding the Aliso Canyon leak, it wouldn't really be towards the utility company as much as the Utilities Commission, which is now making decisions about whether gas lines are open or closed. It's a difficult question, I know, but Professor Doremus, do you have any sense in how, whether we're looking at the federal EPA or state regulatory bodies, or in this particular area, looking at utilities with a gas leak that has had, I don't know that we know the full extent of the environmental impacts, but there were certainly health impacts of residents there who had to be evacuated. Where do we find the targets of lawsuits that are intended to remedy these issues?
That's a good question, and let me see if I can say something a little bit useful. I do remember that blowout. I've not followed the litigation at all closely there, so I don't know any of the details of that. I would say that sometimes one of the things that courts are good at is holding other government agencies' feet to the fire. So we know that sometimes agencies like, say, EPA, the Public Utilities Commission in California has had certain issues. Sometimes agencies don't do the jobs they've been assigned by the legislature in the way that they've been directed to do it. And actually, environmental laws in the United States they're one of the first places that we expressly recognize this and deliberately built in the ability for citizens to bring lawsuits, either directly against violators who weren't facing enough enforcement from regulatory authorities, or against the regulatory authorities themselves for not doing their job. And sometimes that's the right target of the litigation. I think in the climate context, that's really difficult, although there are places where, certainly, I mean, Massachusetts versus EPA was at the time asserting that it had no authority to regulate greenhouse gases, and that litigation made it confront that question and find that, in fact, it had a duty to regulate greenhouse gas emissions. So that's a case, I think, of litigation pushing the regulatory body to do what already is their job.
Got it. Well, we're in our last couple of minutes. I just wanted to give you each a 1 minute lightning round, as we sometimes do here in these series. Just as we have a group of electeds here and others that may be watching, and other students as well, what is a kind of concluding thought that you would have us think about as it relates to addressing what we've all agreed are a set of environmental issues that need response, but what would be the best way to do that? And Mayor, we'll start with you. Oh, you are.
I think incentives drive change the fastest. There is a role for, obviously, for a regulatory standpoint and accountability, and we put some of those into our climate action plan. And again, I really want to stress that you can file lawsuits, and then I'll tell you, I just agreed with what the professor just said, particularly with the example that I just used about another agency not doing what it was supposed to do, the International Boundary and Water Commission, in the case of the sewage coming on, huge environmental issue. They weren't doing their job, so you have to hold folks accountable. And I also think, from an overall standpoint, if we want to affect change faster, quicker, with more clear rules of the road, you do that through policy. You do that through legislation. Because I think, we had a lot of discussion today, and rightfully so, about standing and about what the remedies are going to be, and those are years and years out at this point. I think we want action now, and I think that's why it's up to policymakers to hash it out and to actually put forward policies and to get them adopted, and then hold people accountable. It's the fastest way we're going to make the kind of changes that we want.
Professor Doremus?
I agree that it's important to do things fast. As I said at the outset, I think it's important to have all of our institutions involved, and including private markets. I do think that sometimes litigation can help get people to the political table in a way that they would not otherwise be there. I don't know that these climate litigation lawsuits are having that effect. I'm not involved in any of them, so I don't know what the folks bringing them are thinking. I'm quite sure that's what the folks who brought the Connecticut versus AEP, they wanted to help catalyze legislation. And so I think that's a legitimate use of lawsuits sometimes, is to get the attention of people who are otherwise able to block changes to the political status quo.
And Phil?
Yeah, I mean, I obviously I agree with Professor Doremus. That's the goal of these lawsuits, and that's what's being tried. I just don't think that's the propriety of the legal system, is to bring a case that doesn't have legal merit with the hope that it'll have some external impact on the political environment. I think, if there were standards to, she mentioned before about sort of, dealing with violators. These are not people or companies that are accused of violating emissions law or violating energy policy, and that's what the role of the courts would be to enforce that. With the role, as Mayor Falconer is saying, of the legislative and regulatory bodies, is to establish those bounds and those boundaries of what these companies need to and should be doing. And so, there was a former labor secretary under Clinton, Robert Reich, that talked about the use of courts in this way. He called it faux legislation that sacrifices democracy. He was initially for the, kind of using the courts to regulate. And then when he realized it's really just going around the checks and balances of the political process and going away from, the public input and public accountability, that really wasn't what the courts are for. And so at the end of the day, again, I think we all agree things need to be done. I think we all agree that that includes in the energy sector. But the litigation isn't going to solve anything. It's certainly not going to do it quickly. And it just becomes this way to try to put off and say, this isn't really my fault, isn't really my doing. I don't have to do anything. Let's just sue somebody else and make it their problem. And if that's being done as a way to get them to the negotiating table, I just don't think that's an appropriate use of the court system.
Well, Kevin, Holly, and Phil, thank you very much for an important and timely conversation. As you've proposed that we do, we will be following this Boulder case to see if the court takes it up and what the next steps might be here. And obviously we'll be following these possible cases here in California as well. This will conclude this next webinar in our California to Capitol Hill event series, but please stay tuned as we host other conversations like this in the future for policy issues that have both federal and state level implications here. Each of you who registered for this event will be getting a link to this conversation, and I certainly welcome you showing it to others. I thought this was really a great exploration of what is a very important topic and set of policy discussions as well. So thanks again to each of you for joining us today, and please stay tuned for our next California to Capitol Hill conversation. Take care.